President of this 62nd session, Your Excellencies, AALCO Secretary General Dr. Peacekeeping, legal advisors, fellow members of the UN International Law Commission and participants. I am grateful to AALCO for its invitation and will present a proposal which I have made at the AALC for study, namely accountability for crimes committed against UN peacekeepers. The concept of peacekeeping has developed through the practice of the United Nations as a most positive contribution of the UN for the maintenance of international peace and security. As the world celebrates 75 years of peacekeeping, we all are reminded that peacekeepers often serve in complex and deteriorating security environments where they are targeted by hostile actors and face asymmetrical threats. Of the 4,370 UN peacekeepers who have lost their lives serving under the UN flag, 1,601 died due to illness, 1,493 in accidents, and 1,130 due to malicious acts. The UN Security Council, the General Assembly, the Secretary General, and several mechanisms have expressed serious concern regarding challenges in bringing to justice the perpetrators of crimes committed against UN peacekeepers. In this regard, the low rate of prosecution of such crimes contributes to an environment of impunity and undermines the safety and security of personnel. Rising impunity affects 123 troop and police contributing countries and adversely impacts peacekeeping. As distinguished delegates may recall, to prevent aggravation of this trend further, the Security Council unanimously adopted Resolution 2589 in December 2021, co-sponsored by more than 80 member states, on strengthening accountability for crimes committed against UN peacekeepers, in which it called for a renewed focus on measures to bring justice the perpetrators of such acts. Several mechanisms of the UN, including the Group of Friends, focuses on substantive discussion on providing legal frameworks to support the concept of accountability for crimes against UN peacekeepers. Why we need to address this urgently? Peacekeeping has evolved from a primarily military model of observing ceasefires and the separation of forces after interstate wars to a complex model of many elements, military, police and civilian, working together to help lay the foundations for sustainable peace. This transition from traditional UN peacekeeping operations to the contemporary robust peacekeeping requires an examination of international law protection entitled to personnel involved in peacekeeping operations. As this evolution has given rise to an area of complexities in the application of governing international law, and the legal gaps can be filled only through detailed study of state practice, jurisprudence, and emerging doctrine. There are gaps in the existing legal framework. 1994 Safety Convention and 2005 Optional Protocol and the subject have been unable to address the challenges. Peace operations have undergone a rapid evolution, shifting from traditional peacekeeping to multi-dimensional operations with increasingly robust mandates. The period has also witnessed notable escalation in fatalities resulting from malicious acts. It is now imperative to recognize the emerging trends in peace operations, underscoring the necessity for a review of the legal aspects pertaining to accountability for crimes committed against UN peacekeepers. There is a need to clarify the international humanitarian law protection entitled to peacekeepers. It is imperative to identify elements of distinction between UN peacekeeping acting under the Security Council mandate and in the interest of the international community, and state or non-state actors who pursue their own positions. Peacekeeping ministerial meeting in Accra, Ghana in December 2023 led to few conclusions. That one, while the Safety Convention does define certain crimes, it does not encompass contemporary threats like disinformation or misinformation campaigns, which could indeed jeopardize the safety and security of peacekeepers. 2. The importance of establishing a consistent and clear definition for what constitutes a crime against peacekeepers. And C. Emphasizing the need for updated legal framework to address evolving challenges. There are also significant challenges in procedural law affecting investigation and prosecution. First, Article 9 of the Safety Convention, which provides for the definition of crimes against United Nations and associated personnel, obliges the state parties to penalize the offence under domestic legislation. Similarly, second, from criminal law and procedure perspective, the United Nations does not have the authority or capacity to conduct criminal investigations in respect of alleged crime committed against peacekeepers occurring in the host state's territory. Third, the United Nations may only conduct internal investigation for administrative purpose and does not have the legal authority to compel witnesses to cooperate in its investigations. And there may be obstacles regarding the admissibility of United Nations investigations reports under the criminal procedure law of member states. The Safety Convention, which emerged in the aftermath of crises and conflicts of early 1990s, Gulf War, Baltic crisis, Rwanda, has been unable to attract wide ratification due to 1. Lack of legal clarification, which is crucial for the implementation of the convention in domestic courts. 2. Clarity on the exact scope of the convention. And C. Non-inclusion of some international engagements that are undertaken by the United Nations. The legal challenges to peacekeeping are real and these need to be addressed. It is in this regard I am reminded that can we also undertake such a study, because various mechanisms have been seeking comments and clarifications. For example, are there standard operating procedures for dealing with the cases of accountability? Do these SOP vary from mission to mission? Is there adequate political support and advocacy for promoting accountability? Are there any external challenges to promoting accountability? And are any policies being evolved to address these issues? Whether all crimes against peacekeepers should come under ambit of accountability or not just crime that led to fatalities? What are the mechanisms to prosecute criminals after mission had closed? How could member states contribute to promote accountability? And are there any mission level mechanisms to enhance the capacity of host states? Distinguished delegates, the legal needs, interests and concerns felt by states and the international community for identifying, assessing and taking measures of accountability towards the peacekeepers remain one of the most important steps forward for the overall protection and safety of the UN peacekeepers. Consequently, the efforts of the International Law Commission in codifying and progressively consolidating international law in this area will be of direct practical value. The world is celebrating 75 years of International Law Commission and also 75 years of UN peacekeeping. A study on this vital aspect will be one of the long-lasting tributes to all UN personnel serving in peacekeeping operations, including those who have sacrificed their lives in the line of duty for the cause of peace. Alongside my statement on the above specific topic, with a view to strengthen contribution of AALCO to the work of the ILC, it is my honor and pleasure to brief and kindly request distinguished delegates. 1. To send their comments and observations on 4 topics currently on the ILC active agenda. 1. Immunity of state officials from foreign criminal jurisdiction by 15 November. 2. General principle of law by 1st December. Sea level rise in relation to international law by 1st December and non-legally binding international agreements by 31st December to the United Nations Codification Division. This will help ILC to analyze national and regional content and approaches to make the ILC work as much universal as possible. I would like to inform that subsequent to my appointment as chairman of the working group, on succession of states in respect of state responsibility, an active topic on the AALCO agenda, I briefed the 6 committee members on 5th September as how I wish to approach to complete the work on the topic. I am very much looking forward for learned and practical views of member states on this topic during the 6th committee debate next month. The Commission will also consider a proposed item next year concerning a survey of international law in relation to the work of the AALCO, which is vital for strengthening the rule of international law-based world order. An active participation of AALCO members and all African states will be highly valuable. As distinguished delegates may recall, the International Law Commission celebrates 75th anniversary in the service of the humanity through means of international law. Commemorative event on this occasion is an important means to promote studies of international law. I am pleased to inform that the Rashtriya University, an institution of national importance of India, organized a commemorative event in March 2024 and an event to strengthen international treaty framework in collaboration with AALCO, generously funded by the Ministry of External Affairs of India. As we gather here, the University of Johannesburg in South Africa, in collaboration with the RRU Center of International Law, is organizing a commemorative event on 28 November. During the International Law Week next month, there will be a similar event in the UN headquarters. In this regard, a few more such online or hybrid events in various AALCO members would be very useful. To further strengthen the interaction and better awareness on the work of the Commission for the benefit of the member states, it would be useful if the AALCO chair, through its permanent representative to United Nations Geneva, organize an annual interactive session between the representatives and the AALCO members, and the same may be considered as a side event during the International Law Week in New York too. I am also pleased to inform that subsequent to the appeal by the International Law Commission and the United Nations Secretary General, AALCO Trust Fund has become a reality to support the work of the special rapporteurs and chair, especially from developing countries. I take this opportunity to express deep gratitude to Austria, Czech Republic, Cyprus, Finland and UK for their generous contribution to the same. And as a member of the Commission, I appeal AALCO member states and observers to contribute to the AALCO Trust Fund. I also like to make an appeal to contribute to the International Law Seminar, which enable young lawyers, especially from developing countries, to familiarize themselves with the work of the Commission and international organizations based in Geneva. Since its inception in 1965, 1,334 participants representing 178 nationalities have benefited, and 814 participants have received a fellowship. Several national and sub-regional societies and associations of international law in Africa and Asia are playing their own role to promote dissemination and wider appreciation of international law among faculty, students and legal community. And I take this opportunity to thank them through you and also appeal distinguished delegates for more support to such institutions of learning of international law. Importance of international law as a common language for addressing contemporary and futuristic issues and challenges for the promotion of cooperation and understanding in interstate relations for peaceful coexistence, sustainable development, respect for human rights, and peaceful settlement of disputes of the whole humanity is felt more and more at all levels. And I thank member states and AALCO for promoting this mission by all possible ways and means. Distinguished delegates, my written statement in all UN official languages will be given to the AALCO Secretariat. I thank you for your kind attention.